Welcome to this webinar about ABCF safeguarding procedures in Poland, organized by Safeguarding Hub Eastern Europe. My name is Karolina Mackiewicz. I am representing Poland Eastern Europe Hub. We will tell you about what these are not, and we will talk about the context in Polish organizations. To do this, we have invited two panelists who will drive us through these parts of this webinar. First, I will talk with the global expert Lucy Heaven-Taylor about the basics, so ABC of safeguarding administrative procedures. Then Agata Szerszeńska-Dubek from Polish Humanitarian Action will talk, who will extend our knowledge about the Polish context. The webinar will contain content about safeguarding, which can be stressful. We'll hope that it will be not too stressful, but if they will be, then we are sorry, but the topic is difficult. Our first presenter is Karolina Mackiewicz, has more than 20 years of experience in the field of fighting sexual abuse. She started in her career in Bosnia and Kosovo. She worked for clients like UN Women and the Human Development Office and the SHS Alliance. She's a member of the Independent Reference Group for PSA. The technical affairs for the PSCA committee, and she is a member of the PSCA experts committee. She's a regular panelist at the discussions, and she works with the UK Parliament's International Development Committee. So I welcome Lucy, and I give her the floor.
Thank you so much, Karolina, for that introduction. So good morning, everybody. As Karolina said, I am going to take you through an introduction to safeguarding and PSCA investigations. So you will all probably have heard the terms safeguarding and PSCA investigation, but it might not always be clear what it is exactly that we mean by that. So I'm going to start with the basics. What is a safeguarding or a PSCA investigation in the humanitarian and development sector? So in our sector, a PSCA investigation is a workplace administrative investigation. It takes place when further information is required to find out if a staff member or a volunteer or someone working on behalf of our NGO or CSO has breached our organisational PSCA policy or code of conduct. So it's not a legal investigation, it's a workplace investigation into misconduct, as we might see with other workplace issues such as bullying and harassment. So just a note on the terminology that we're going to be using in this presentation. First of all, what is it that we actually mean by safeguarding? It's not a widely used term in Polish. In fact, it's not actually that widely used in English either. So just to explain it a little bit more, in our sector, it means preventing harm that is caused by our staff or our volunteers or our programme design and implementation. And by harm, we mean physical, emotional, or sexual harassment, exploitation, or abuse. By PSCA, a term that you might have seen in various networks, we mean protection from sexual exploitation and abuse by our staff and volunteers. So it's a subset of safeguarding. It's part of safeguarding, but with a specific concentration on looking at sexual exploitation and abuse. We will use the term survivor in this webinar. By survivor, we mean the person who is or has been sexually exploited or otherwise abused. Some people use different terms. So some people use victim, for example. We use survivor because we think that it's an empowering term. However, the person who's experienced the sexual exploitation and abuse can choose whichever term they prefer to describe their experience. Survivor-centred means that when we do anything to do with safeguarding or PSEA, that the survivor's wishes, safety and well-being remain a priority in all matters and procedures. So this means over and above, let's say, protecting our organisation's reputation, or protecting our funding, the survivor should always come first in our decision making. So when does a safeguarding or PSEA investigation actually take place? So I've spoken about the different types of harm that can be caused by our staff or volunteers or someone associated with our organisation. So if it seems as if there has been some harm caused by our staff, the first question to ask is, does this incident possibly, was it perpetrated by our own staff? If it's something that we've heard about, but it was done in the wider community, then we would immediately refer it to the relevant authorities. However, as I say, what we're concerned with is misconduct by our own staff. So the next question we're going to be asking is, this incident that we've heard about perpetrated by our staff, does it potentially represent a breach of the law in Poland? If it does, then that's no longer a staff misconduct issue. Of course, that's a legal issue. So it's referred to law enforcement, if it is safe to do so for everyone involved. As we know, sometimes referring to law enforcement, particularly when we're talking about issues of sexual exploitation and abuse, may not be a safe move for everyone concerned. However, by default, we would refer it to law enforcement. If this safeguarding or PSEA incident does not necessarily represent a breach of the law, but it is breaking our own internal policy or code of conduct, then the next question we ask is there enough information to make an immediate decision about this? For example, did lots of people witness this incident? In which case, it might be immediate dismissal, or we might not have enough information, even the name of the perpetrator, in which case we might just save it onto file and see if any future similar incidents occur. But if we do have enough information to take this forward, but we need to find out more about what happened, that's when an investigation might be required. So as I've already said, this is a workplace administrative investigation, as we would do as employers into any workplace misconduct. But what makes a sexual exploitation and abuse investigation different? Well, because these are sensitive issues, of course, there is a risk of re-traumatization with the survivor if we get this wrong and if we do this in an inappropriate way. And also even possibly a risk of traumatization for other people involved, such as witnesses. There may be potential safety and security risks to the survivor and others involved. If this sexual exploitation and abuse has taken place and our staff member wants to cover it up, they may approach the survivor to coerce or threaten them. And that's something that we need to be aware of. There are also, when we look at sexual exploitation and abuse, there could be sexual exploitation or abuse or harassment that is internal to the workplace. For example, a staff member is sexually harassing another staff member. This will be dealt with by a different set of policies and procedures than if our staff member is harming or abusing somebody they come into contact with, so a beneficiary of assistance in the course of their work. So if it's workplace harassment, the legal and policy framework will be different from if it is causing harm to somebody who is a member of the public. And we need to be aware of what those different policies and procedures might be. So how do we undertake a safeguarding or PSEA investigation? First of all, we will need to assign the roles and responsibilities. And there are two different sets of roles and responsibilities in this investigation. First of all, there is an investigation manager or even investigation management team in larger organizations. Their responsibility is to commission the investigation, to develop the terms of reference, to ensure support to the investigation team. And then once the investigation team's work is concluded, the investigation manager will receive the report. They'll see if they agree with it and approve it, and then they will make decisions for follow-up. The role of the investigation team, and we recommend a minimum of 2 people on this team, is to conduct the investigation. And that usually includes looking at any documentary information that there might be, for example, screenshots of WhatsApp messages and other pieces of information, and also to conduct interviews of any witnesses that might be involved. And that includes, if they wish to be interviewed, the survivor. And of course, we also interview our subject of complaint, our staff member against whom the allegation has been made, so they can put their side of the story. The investigation team then produce a report in which they compile all of the information and reach conclusions. Now, the reason why these 2 roles are separated is, of course, for transparency and impartiality. It's important that the person making the decision is separate from the people who are gathering the information, so that you have that extra layer of transparency. So this is what usually happens in an investigation. First of all, if we hear about a safeguarding or SEA incident, the first thing we do is to offer the survivor support. And this is regardless of what we think the outcome of the investigation might be. We still go ahead and offer that support, and it can be psychosocial support, legal support, or medical support. Next, we assign the roles and responsibilities as per the previous slide and develop the terms of reference. Then the investigation team get to work. They review whatever information there might be already, and they develop a plan for the investigation. They then undertake interviews, as I've mentioned. They then put all of the information that they have together and they analyze it to see whether they have information that can either uphold the allegation or disprove the allegation. They then write a report with their conclusions, and as mentioned, they then refer that to the investigation manager to make a decision. So I mentioned being survivor-centered, putting the wishes and well-being of the survivor at the center of what we do. So how can we make investigations more survivor-centered? Because they are actually, in fact, a workplace process. So we recognize that survivors are experts in their own situation and know what's best for them. That we should consider, because of the risk of re-traumatization, whether an investigation is always necessary or whether there are other options that we can undertake. Investigations should proceed with the informed consent from the survivor. So we tell them that we're going to do this and let them know what's going to happen, and they decide whether they consent for it to take place or not. And they can choose whether or not they want to participate. The exception to this is cases involving children under the age of 18. If we come across a case involving children, we would always refer that to law enforcement because we always act in the best interest of the child. We say that survivors can be accompanied by a support person if they would like to be. And that person would be separate from the investigation, but would help them and support them through the process. Investigations should always follow sector standards, and you can find those standards and more information on the RSH website. We'll tell you more about that at the end. And they should always use trained investigators. And finally, we recommend that investigations use the balance of probability as the evidentiary threshold to make decisions. And I'll tell you a little bit more about what that means if you're not familiar with it. So the threshold of evidence is what we use to decide whether we think the incident has taken place or not. So in a workplace investigation, we usually use balance of probability as that threshold. And it means that something is more likely to have happened than not. As I mentioned, this is not a legal investigation. Legal investigations usually use beyond reasonable doubt. So we're not using that for our workplace investigation. And of course, as we know, it's very difficult to prove in cases, particularly of sexual exploitation and abuse. They are almost never witnessed. They take place behind closed doors, And it's very hard to reach a conclusion beyond reasonable doubt of what happened. However, some organizations, including some UN organizations, do use beyond reasonable doubt, and some use another higher threshold of evidence, which is clear and convincing evidence. So they say these are much harder to prove, so we recommend that you use the balance of probability, as if that is usually a standard in a workplace investigation. So when we're looking at our potential conclusions to our investigation, different organizations use different terminology, but there are usually one of three conclusions that is reached. The first is the allegation is upheld due to information to prove the allegation on the balance of probability. The second possible outcome is that the allegation is not upheld due to information to disprove the allegation on the balance of probability. This is reasonably unusual. It is possible to get malicious reports of sexual exploitation and abuse, but that's very unusual. The likelihood, as we know, is that in fact sexual exploitation and abuse is so rarely reported, it's very underreported. So it's very unlikely that somebody will come forward and make a malicious claim. The third possible outcome is not upheld due to insufficient information to prove the allegation. So we're always defaulting to the responsibility of the organisation to prove on the balance of probability that this staff member did in fact perpetrate misconduct. If we're not able to prove that, then that staff member's record is cleared. So what happens next? We'll make a decision what to do next based on the investigation conclusions. And that is the role of the investigation manager and other senior managers within the organisation. If the allegation is upheld, it may go to disciplinary hearing. If it's not upheld, as I mentioned, the staff member or volunteer's record is cleared. Support to the survivor continues for as long as they want it. Survivors of sexual exploitation and abuse might not always want to access support in a linear fashion. Research shows that most people do tend to look at accessing help, let's say 3 months after an incident has occurred, but even that, of course, doesn't reflect everyone's experience. And they might want to go on accessing support for many years to come. And then finally, justice for the survivor. This is a question mark because this is something that is not often discussed widely in our organisations. What is our liability to the survivor? Should we be offering financial compensation? This is something where there is not a decision or a widely held area of practice in the humanitarian and development community. So that's one that we need to go on discussing. Oh, sorry, that was the things that I've just discussed are on the slide there. So moving on to what help is available on investigations. So as I mentioned, the Safeguarding Resource and Support Hub has lots of information to help you. You can read our website in Polish, where you will find lots of resources, and there is also a help desk that you can access. But Karolina will tell you a little bit more about that at the end of the presentation. So that's it from me. I'm going to hand back to Karolina now, who is going to introduce our next speaker. Thank you.
Thank you very much. That was very interesting. Your presentation was extremely excessive, and I would like to encourage everyone to reach out on this website. And now I would like to go further on the topic of Polish Humanitarian Action. And I would like to hand over the voice to Agata Szerszeńska-Dubek. Thank you very much for presenting me. And Julie, thank you very much for your interesting presentation. I will have a very short presentation, which comes from our Polish legislation. And Lucy, not really sorry for the former one. I hope that I will serve you with many many information. So, as you heard already in Lucy's presentation, if there are people to whom occurred some inappropriate events, action, and they decide that then they will have an internal investigation, they need to write a written consent that they will share information about event. Sometimes, as Lucy mentioned, it's very impossible or very hard to make decisions, but and to take an investigation and start the investigation process. It's very important to inform the firstly person to whom the investigation occurs to. We need to tell them that that all the actions against her or him are under legislation. This is our social obligation to take care of them and to take care for their rights. The obligation to inform law enforcement, and this is a legal obligation, and it will be under the Code of Criminal Procedure. So anyone who has knowledge that an offense prosecuted was committed to has a citizen's duty to notify thereof the public prosecutor or the police. But in some cases, more likely with these actions, which have an absolute duty to notify the possibility of a crime when the crime involves the most serious offenses, the legislator listed them in article of the criminal code are like we are uh, we are under law enforcement, so we have the obligation, and it can lead us to penalty, the imprisonment up to 3 years, because if we failure to inform law enforcement of crime in the case of offenses like murder, deprivation of human liberty, rape, sexual exploitation, the penalty is the same as above, uh, which could be imprisonment for up to 3 years. We need to have in mind that the feeling of notification of a suspected criminal offense should not relieve us of our responsibility to the protection of the whistleblower and the victim. Our role does not end there. So all the obligations are in our burden. Topic is a very sensitive topic because the internal investigation and data protection regulations do not directly mention internal proceedings, right? However, this does not mean that they do not apply to them. On the contrary, they can play a very important role in drawing the line between legal and unlawful action. Please remember that personal data can only take place if at least one of the prerequisites listed in the data protection law is met. In case of internal proceedings, they may include the consent of the data subject, and this consent must be freely given, and the necessity of the data processing for the fulfillment of legitimate purposes pursued by the data controllers. And anytime when we turn for such help or investigation in the investigation procedure, there will be internal legal obligations, and we need to remember that we need to balance whether we can fulfill the requirements that's by the law to not to harass the data security data policy regarding the victim or the survivor. We talked about security and safeguarding better of the person, let's say her survivor, and the potential problems for organization. I must say that no provision of the labor code allows an employer to safely release an employee from his duty to provide work without any connection with the termination of the employment contract. So many cases are just diminished to mobbing, and they are not considered as harassment. And the second, the first can be entrusting the employee with other work than specified in the employment contract, which can be maximum 3 months. The second is issuing an order to employee to take outstanding vacation. And sometimes there are cases that the whistleblower itself knows already, or somehow he hears that there will be an investigation, him or her. So he will go for a vacation, for a paid or non-paid vacation. When we made our investigation and we made the GDPR legislation met and fulfilled and totally, we still have potential problems for the organization in terms of legal relationship with the perpetrator as a result of internal proceedings. The dismissal due to violation of the code ethics, it's always conducted by very clearly stateable harassment or any other action. So the labor code requires that the employee crime, which the employer intends to treat as a reason for dismissal, must be obvious and to be established by a final judgment. And the labor code, the offense for the labor code, the offense must be obvious. For example, there must be indisputable evidence of the commission of criminal act, like capturing the perpetrator in the act of committing the crime. It's barely possible. These kind of proceedings. And we were passing through or pushing through to put into the work policy and regulation to make very clear description of which include the harassment and what will be the consequences. I think that these were the biggest problems or questions related to Poland, what we need in Poland, and please listen to others. Thank you very much, Agata, for giving us a narrative, a Polish narrative. Please post your questions. The first question related more for what we got from Adam is the probability. What is the probability? So not to wait until all the evidences are clear, but when we feel or touch a probability of such an event, we shall give a decision, a certain decision, in order to set up a proceeding, an internal proceeding.
So I think Adam's question maybe relates to what I was saying about the balance of probability as being our evidence threshold. And Adams said, does that mean we don't wait for full certainty? I think it's slightly different from that. What it means is that the investigation team gather all the information that they can find, and they then analyze that to make their decisions, make their recommendations. So it's not that they are concluding the investigation without waiting for full certainty or without doing further activities to gather more information to get full certainty. It means that they have got all of the information that they think is relevant, and based on that, they are making a recommendation on the balance of probability. And to explain a little bit more about the balance of probability, I don't know about the translation into Polish, but it means it has a slightly different meaning from just something probably happened. What it means is that we sometimes describe it by saying that if you ask 10 people if they agree with the information and they think that something happened, if more than half of them, so if more than 5 say, yes, I think it did happen, then that's the balance of probability. Of course, we are looking for more than, just over 50 agreement on that. And that's the reason why we have 2 separate roles and responsibilities, so that the investigation team, they can look at the information and they can say, yes, I think based on this information, this incident happened on the balance of probability. And then the investigation manager can also read it and say, yes, I agree with that recommendation. I've looked at all of the information and I also think that this incident probably happened. It's not a guess, it's based on lots of information that all adds up to indicate a certain conclusion. And as I say, this is a workplace investigation. So we are just looking for enough information, for example, if we need this case to go to a disciplinary hearing. So I hope that helps to answer the question. And I don't know whether Agata has something else she would like to add on that.
Yes, I may. I would like to add. Shall I take voice and answer on this question? Ladies and gentlemen, it's not perpetrator who comes from outside and is completely unknown. Because many employers are very confident, not confident, but very knowledgeable about the mobbing, and they are just not caring. Because we presume, because this is it, how it is on the workplace, and this even can happen, because everybody presumes that nothing more. And a little alarming can show us that it will be potentially enlarged. And these are the elements which become very relevant in the investigation process. Because Agata was mentioning at the very beginning that these perpetrators are very often financially or internally based higher. And thank you, Agata. There will be another question.
How to proceed if the anonymity of the victim was not kept secret during the procedure? How to provide proper defense to these people? It's difficult for me to talk about this because this is more linked to organizational questions. In my organizations, whenever we do such procedures, we use a clause of undisclosing data about this this issue, and if someone does not keep this in secret, has to face consequences. We have some material, we have mails, we have messages, we talk with people. It is not possible that if we talk with these people on a large scale, of course, these people are also obliged to keep this information secret. So for this reason, a part of the clauses, of course, This is a legal solution. It is worse to exclude this person from work, as I told, and also it is very information to have training about these issues, because if this person did not do anything, but the gossip goes around the organization, it will not be possible to stop. So this person, about this person, everyone will think that there was some truth in this. If this procedure was finished and there is a result, then of course it is clear who was the perpetrator and who was the victim. Of course, we cannot keep this person in an unsecure situation. We have to be transparent. If some disciplinary steps have to be made, this person will have to know about them, which was the reason, especially if his work agreement was dissolved. This information had to be included in that. I don't know if it was a proper answer. Thank you, Agata. There is another question to you. How to construct a code of ethics without being accused for discrimination? Maybe you should tell about that something, though it is not in the scope of our webinar. There is a lot of literature about that on our website. We are trying to share that in the chat. We will send the links. But Agata, if you have to say something about this in the context of this question, then you are welcome to do so. Of course, we talk about the ethics code rules about sexual harassment. It's difficult to imagine that these rules should be discriminative. Of course, if you are interested in these safeguarding procedures, also in training about this, there's a lot of them in our sector. There's a lot of procedures that are for a Polish lawyer should be controversial. For example, there's a very high consent age, but everything can be defended. We defend the beneficents. I didn't find so far any situation when it would be a problem that these rules are too strict. We use them for all the people. I can't imagine how could it be discriminative. Maybe if we would not employ people who would be sentenced for some crimes. Both organizations and companies put together very strict ethics codes, and the basic rule is that we treat the same people the same way. Lucy?
Yeah, I agree with Agata, of course, and just to add that, remember, this is a code of conduct for employees whilst they're working for the organization. So because humanitarian organizations find themselves in a position of power over others, because they have goods and services that other people, particularly vulnerable people, might need, that's why we have stringent codes of conduct. Because when you have that power, there might be one or two people who choose to abuse that power. So in other professions where we also ask very high standards of behavior, for example, teachers, medical profession, again, where they have power over people who might be vulnerable, it's similar in the humanitarian sector. And we always remind people that you are choosing to work for this organization. The organization should be clear about what its approach is and what its code of conduct is. And you're making a choice when you become an employee that you're going to adhere to those standards. So it shouldn't be seen as an infringement on people's rights that we ask for particularly high standards of conduct. And as Agata said, she's found nothing in Polish law that that means that our codes of conduct and our high standards cannot be defended. Thank you.
Thank you very much. We have a moment remaining, 5 minutes. I'd like to ask a question that I get very many times on trainings for NGOs. There will be 2 questions in one. First is how to, what kind of rights you have to have to conduct procedures inside the organization related to safeguarding issues. And we also ask this question in the context of the teams that make such investigations in Poland. The Polish reality is that we have very limited human resources in this context. We cannot afford an investigation team and also an investigation chief in terms of safeguarding procedures. It happens frequently that the whole staff is 5 people. So if there's an incident, they cannot be investigated by a large team with members and internal investigator and also a separate manager. Agata, do you have something to say about that, to us how to do it in Poland in case of lack of appropriate competences, or maybe we do not need competencies to conduct such an investigation. I also propose a monthly course. I also have a problem. So there's a lot of trainings that you can send your people to. It doesn't have to be their only job. This person who will have such a knowledge can be such a person can be in a investigating team, but not only. There's also a lot of other organizations that provide such training. There's one thing what you can learn in such trainings, and the other is how you approach to other people. I don't know if I can tell concrete names because it would be some kind of marketing, but about the topics. They can be found easily in the internet about safeguarding procedures. In order to feel safe, you can take part in such a training. With that training, you can also say that you in an organization there is a person who has the competencies. These persons after the training make a test and get a certificate, so these people can feel safe that they have a knowledge needed for that. So how about also elicited about that if there would be a team of more than 2 people investigating such issues, so there would be not just 50-50. Lucy, do you have something to add? Just 3 minutes. How this teams people could take part in these investigations, or it is possible to have just a smaller team of a few people?
Thank you, Karolina. And I missed the interpretation on the first part of Agata's answer, so apologies if I repeat anything that she said. But yes, of course, we recognize that if you are a small organization, maybe you have only 3 staff, then of course it's very difficult to separate out those responsibilities. So firstly, just to say that the role of managing the investigation should always be within the organization, because that person then needs to take decisions. So as I think Agata mentioned, you can look to other organizations to see if they have people trained to bring in an external investigation team. There are consultants who can do this, and there's a consultants directory for Eastern Europe on the Safeguarding Resource and Support Hub website, but of course there will be even then a cost associated with that. So it can be difficult, to tell the truth, to have this capacity. I would say that it's always worth asking your donors if they have any funds available, if you have a serious incident, to support you on this, because it's the donors are very engaged in solving this problem of sexual exploitation and abuse. So they should really be, if they want to solve this problem, they should be providing the funds and support to do so. So for example, I know that OCHA, the Office of Coordination of Humanitarian Affairs, if you are getting funding from them, they have a fund that you can apply to for investigations, and I'm sure that there are other funds available as well. So don't forget to ask your donor if there's any financial and capacity support that they can provide you on this, because we do understand that it is difficult to conduct a thorough investigation when you are only a small organization. Oh, and Agata mentioned training that's available. Again, I think there are details on the Safeguarding Resource and Support Hub of where you can go for training on investigations.
Thank you. And this is all that we have time for today. There were questions about how to get knowledge about conducting such procedures. So please then write to me. Thank you very much for Lucy, for Agata, for these very interesting presentations. Thank you very much. And we hope that we will meet again. I'm greeting you all. Thank you very much.